the power and the limits of power which a court possesses to determine an issue or a matter placed before it. So, in other words, when you talk about power, no power per se is absolute. So, a power donated to someone also has its what? Its limit. If, for instance, you have sent somebody, maybe let's say your father, you send your father to go and buy me bread, and the father comes with half bread, what will be your response to the person? You know what I mean, like your junior friend. Send your junior friend to buy you bread. As at the time the junior friend is coming, he's chewing the bread. I said, sir, this is the one I remember for you. Why would you get angry with him? Because, good, you gave him money. The money gave him power to purchase something for you. And that's the limit of his power. Buy that thing and bring to me. And not to share with you. Right. So every power has its own limitations. So that is how they operate in law. Even by the time we look at unlimited jurisdiction, you will discover that there is nothing unlimited, because somehow along the line there will be a limitation. Yes, sir. So this is how power operates. It's the power given to a court as well as its limits. So a court exercising power is cautioning itself, being mindful of the fact that, look, I can't do all things. There is a stage I will get and then I have to stop. So that is what jurisdiction is all about. That power and your limitation to entertain a matter placed before you as a judge. And some of the times, if a matter is placed before you as a judge and you discover that you don't have jurisdiction, you first of all ask the parties, do you think I have jurisdiction? Address me on this. Which means you have raised an issue so much, and you are asking counsel before you to do what? To address you on that very subject matter, whether you have jurisdiction or not. And if in the end you are satisfied that you don't have jurisdiction, what do? You strike out the matter. In other words, you have this power, you also mindful of your limits in exercising that very power. So this much we can garner from the following cases. Ibrahim against Saham, S-A-R-H-A-M. Ibrahim against Saham, 2024, 4 Nigerian Wiki Law Report, Part 1927, page 1. Also see the case of NASCO against Bello. NASCO against Bello, 2024, 4 Nigerian Wiki Law Report, Part 1928, page 239. 239. Jurisdiction may either be civil or criminal. Jurisdiction may either be civil or criminal in nature, but each of these two arms has its own components. For instance, in civil litigation, which we are doing now, in civil litigation, jurisdiction simply means the power to entertain disputes between individuals inter se, between individuals and government, or between government and government, with respect to declaration of rights, liabilities, compensation, judicial review, etc. The following are the principles of jurisdiction. If you can get my book on jurisdiction, you will have larger thing to read on jurisdiction there. Following are the principles of jurisdiction. 1, the court must be properly constituted as regards the members of the court, as well as the qualification of the members. 2, the subject matter must be within the court's jurisdiction, and there must be nothing preventing the hearing of the case. Finally, the case must be initiated by due process and upon fulfillment of conditions precedent. The locus classicus on these principles is the decision of the Supreme Court in the case of Madokolo against Nkemdelem, Madokolo against Nkemdelem, you discover in every case of jurisdiction, this case is referred to. Madokolo against Nkemdelem, 1962, 2 SCNLR, 2 Supreme Court Nigeria Law Report, page 342. See also PDP against APC, 2023, 17 Nigerian Criminal Law Report, part 1914 at page 497. And finally on this, the case of Okeke against Abga, 2023, 17 Nigerian Criminal Law Report, part 1913, page 211. The issue of jurisdiction is statutory and cannot be conferred on a court. It cannot be conferred on a court either by rules of court or practice direction. It must be conferred by what? Law. It's statutory. Also note hierarchy of courts which they have covered so that we don't continue running round and round. The next is nature of jurisdiction. I'll mention nature of jurisdiction and give you classes of the nature of jurisdiction. The issue of jurisdiction is very fundamental, the absence of which robs the court of jurisdiction. If for any reason a court of law conducts proceedings without jurisdiction, that proceedings would be regarded as a nullity. This is because you cannot you can conclude it now. So what is it? How is it said? Jurisdiction can be original, appellate, exclusive, limited, or unlimited. When a court enjoys jurisdiction, that jurisdiction is either an original jurisdiction. Original jurisdiction simply means that's why the power the court has to entertain the matter as of first instance. So it can either be original jurisdiction or appellate jurisdiction. And the court exercising an original jurisdiction may as well be conferred with either exclusive jurisdiction or concurrent jurisdiction with other courts. For instance, in fundamental rights matters, it has been settled that the Federal High Court and the High Court have what? Concurrent jurisdiction. And then jurisdiction can also be limited or unlimited, but I will explain that. Limited jurisdiction simply means that the subject matter of the court is listed, or the monetary jurisdiction of the court is listed, and the court cannot exceed the monetary jurisdiction prescribed by law or the subject matter jurisdiction prescribed by law. That means that jurisdiction of the court is what? Limited. Even when you see the jurisdiction of the Federal High Court, in which it enjoys exclusive jurisdiction, most of the matters there are exclusive apart from the fundamental right, which is a special judicial issue. You discover that the matter falling within the purview of the jurisdiction of the Federal High Court is exclusive to them. But being exclusive doesn't mean it has covered everything. So which means it is exclusive and it is still limited to that thing that has been conferred on it. Before 1990 Constitution, it was believed that the High Court has what? Unlimited jurisdiction. It can delve into anything. And now you see some books that will tell you, okay, even under this present Constitution, that the jurisdiction of the High Court is unlimited except for, what do you say except? Once you say except, why are you conceding? There is what? Limited. You see, there's no need to pretend about it. And then types of jurisdiction we've already known: territorial, subject matter, personnel, monetary. And then finally, the effect of lack of jurisdiction, just to underscore it once again, is that it nullifies a proceeding, no matter how brilliantly, ebulliently, and well conducted. It amounts to what? Waste of time. Nothing. All right, see you next time.